hadn't heard anybody say, so I don't know.
Okay, because Gwinnett County has it that students who prefer digital to face will have to take it through Gwinnett online. So,
Oh,
Wow.
okay.
yep, it's interesting.
Interesting.
Hmm.
Yeah. That is very interesting.
Yeah, I think that's a lot of why a lot of teachers are kind of burnt out. You got quite a few leaving the profession too, and I think they're kind of burnt out because of the double duty um,
Yeah.
with face to face and online. It was it's a challenge.
Yeah, I bet. I bet.
Hmm.
I bet. All right. Well, let's see. Well, it's 7:01 and we are already live on Facebook, and it's good to see everybody with us tonight. I'm sure we'll have a few more stragglers to log in and join us in just a minute, but I want to welcome you all to Talk Tuesday. Got an exciting program for you tonight. Um, and just a reminder that if if you're watching us on Facebook and you would like to Zoom with us, you can just go to Zoom and type in the ID, and you'll be able to interact with us through Zoom, which is a good way to chat with us. And so we look forward to you Zooming with us. Just take a minute and switch over. As we shared last week, this month is Mental Health Awareness Month. And so we had a great speaker. Did y'all enjoy the speaker last week? She was pretty good, wasn't she? Let's see. Make sure y'all can hear me okay. Can everybody hear me okay?
Yes.
All right, everybody can hear me okay. Good, good, good. But yeah, we had a good speaker last week. She did an excellent job, Sister Avery. And we're going to have with us next week Tracy Thomas, who's also with Advantage Behavioral Health Systems, to help us talk a little bit more about the things you need to know for Mental Health Awareness Month. But tonight we've got with us guest speaker Thua Barlay, who's an attorney at law, and Tua's going to be talking with us in a moment about estates and wills, and we're excited to have Tua's with us, and we're going to give him the official welcome in just a moment. Uh, but real quickly, wanted to give you a couple of things that you need to know in terms of church updates and the vaccinations. Right now, we're sitting at 262 million doses given in the U.S. To approximately 116 million people that are fully vaccinated, which is 35% of the population. Still a long way from herd immunity, right? 75 to 80%. So we're going to get there. Georgia is at about 28%. So we're a little bit behind the national average, but we're doing pretty good. Females are getting vaccinated. Sister Jen will like this. Females are getting vaccinated at a slightly higher rate than males. So guys, we need to catch up a little bit here. And in Barrow County, which is where we're located, roughly 29% of our population has been vaccinated, which is pretty good. We are surrounded by a few counties that have 35 to 45% of their population vaccinated, but we're doing pretty good. This is an interesting chart. If you look at the vaccinations by the demographics, by groups, African Americans, Blacks, only 27.1% of our population have received at least one dose. And that's compared to American Indians, white, other, and Asian, which are all higher. So I think that speaks to something that we need to be aware of, and that is we need to look at all the avenues in which we can do the things we need to do to get our people to come out and get vaccinated. And of course, Sister Liz, as we shared a moment ago, we started church Sunday, right? We see churches are becoming a very important part in getting the vaccine out and into arms. And so this past Sunday was our first Sunday back at church, and we had a very good turnout. And so the polling question that Sister Liz and others want to know tonight we're going to go ahead and launch that right now. And the polling question is, what percentage of those that attended church this past Sunday were vaccinated? We took a poll of everybody that came in. So let's see what you think. Anybody want to speak out while they're typing in their number? What do you think?
I think everybody probably was. So I go with the 85%.
There you go. That's a
think
great guess.
85% too.
85, Cicely, is okay.
Yeah.
That's pretty good. All righty. Well, let's see. Looks like everybody has polled in. So let's share the results. And it looks like, hey, y'all were just pretty much evenly split. The actual number was 75%. So 3 out of every 4 people that went to church Sunday at our church had been vaccinated, which I think is a great number.
That is great.
It's very good. And we ought to be proud of that, particularly when only 27% of our population is choosing right now to get vaccinated. So that's good news. But churches can play an important role in getting the shots out. And our church on Saturday, May the 22nd, we're going to host a vaccination party, for lack of a better word, from 9 a.m. to 1 p.m. at the church. We want to get the word out and get as many people to come by as possible so that we can get more people vaccinated. So we're really excited about that. So look, stay tuned for more information on that. Now, so without any further ado, I think we're to the point now where we're ready to just welcome with us tonight, Mr. Thua G. Barlay. Thua, glad to have you with us tonight. There he is. Are you on mute?
Can you hear me now?
There you go.
Okay, perfect. Perfect. Technology, right?
Hey, Thua, how are you?
I'm doing fine. How are you doing?
We are great, man. We want to welcome you to Talk Tuesday. And thank you so much for taking time out of your busy schedule to be with us tonight, man.
Oh, no, it's a pleasure to be here. And thank you for the invite. Appreciate it. Always good talking about.
Now, to everybody that doesn't know, you may know, if you deal with attorneys, they normally charge about an hour, anywhere from $300 to $750 an hour, Liz. And so we're getting a deal tonight. I haven't, I got the impression we probably won't get a bill after this meeting. Is that right, Mr. Thua?
I thought we had talked about that. I thought I was going to send you a bill, but it would have been on the lower end of that scale that you mentioned. But no, I just appreciate being here and sharing some of the knowledge and education on wills. So.
Well, good. Well, thank you so much. Well, hey, Thua, tell us a little bit. Now, Miss Carol's on the line.
Yes.
My better half. She could probably tell the group a little bit about you, but since she's kind of out of the pocket right now, tell the group a little bit about you.
Sure, absolutely. Thank you. Again, as Getty mentioned, my name is Thua Barlay. I'm an attorney with Luter, Larkin, and Hunter. I've been practicing law now since 2004. 2003, so about 18 years, primarily in the areas of estate planning and real estate. So I've been a real estate attorney for 17 of those years, and I've been an estate planning attorney for about 15 of those years. So just been in the Metro Atlanta area now since 2002. Graduated from Purdue undergrad in computer technology, went to law school, still in Indiana at Indiana University. Then decided I got a little too tired with the cold weather. And so 4 days after my last law school exam, I packed up the U-Haul and moved to Atlanta because this is where family was. They had moved here after I had moved to the States, originally from Liberia, West Africa, but have been living here now since 93. So just again, happy to be here and share some wisdom and knowledge.
Awesome. Awesome, Thua. Thanks so much. Well, again, we want to thank you for taking time out to share with us tonight. We're not going to ask you to stay too long, but we're just real excited to learn more about wills and estates. Thua, as I shared with you yesterday, this past year has been a difficult year for a lot of families, right? and the pandemic, of course, brought with it some untimely deaths, which also placed some people in some unenviable positions in terms of managing some estates and doing some things that they really didn't hadn't prepared to do. And in addition to that, it caused a lot of people to think about their own personal situations, right?
Yes.
And so we kind of want you to talk to us a little bit about, talk to us from a perspective of why are wills important, and just give us some insight into the whole will and estate topic.
Perfect, perfect. Great. I'm gonna, if I can, I'm gonna share my screen. I have a PowerPoint presentation just to sort of set the stage. I'm gonna try and leave some opportunity at the end to have questions, and even actually, what I say that, but as I go along, if you have any questions at all at any point of topic, just feel free to ask, and we can sort of address it at that point in time. This is a topic that typically lasts about an hour, hour and a half, so I've condensed it down. It's going to be a lot of information for most of you, but I'm just going to try and, if you leave here with just half of understanding half of what I've talked about, it would be a whole lot better than prior to the conversation.
Amen.
So I'm going to share my screen, and hopefully it'll work to do the PowerPoint. So just let me know if you do not see the PowerPoint presentation on the screen. Does everybody?
We got you. We got you, man.
Okay, perfect.
Yeah.
Perfect. So the topic, as Kenny mentioned, is talking about estate planning, planning for life, disability, death, and beyond. We won't talk too much about the probate process, which is the part after you pass away. We'll talk more about the will and the planning side of things, because I'm a strong believer, if you plan appropriately and properly, that it makes it easier to handle the probate process, especially here in Georgia. So we'll talk about some of the more common planning techniques that you can have, and then we'll sort of wrap it up in terms of what an overall plan looks like. Because I try and stay away from the terminology of just wills or just trusts or just estate. I look at it as sort of an estate plan, because you'll realize from this conversation that it encompasses more than just your typical will or the will by itself. And so, as with most conversations, I always like to define the topic, and hopefully I can move this down. It's giving me a little bit. Let's see if that works. Okay, so I always want to define a topic, and this is from the standpoint of you, the individual. So a definition of estate planning is I want to control my property while I'm alive and well, take care of myself and my loved ones if I become disabled, give what I have to whom I want, the way I want, when I want, and then lastly, I'd like to save every last tax dollar or professional fee, court costs legally possible. So
Hey,
really,
Thua,
yes,
one
sir.
quick question.
Yes, sir.
I had one question that just came from a listener, and
Okay.
so they won't have to take as many notes. Is there any way you can share this with me later, and I can reshare it with those?
Absolutely. I will
Okay.
email it to you right after we get done. And
Perfect.
yes,
Thank you, sir.
You're welcome. And so the definition really focuses on three main areas. It's really about control. So while you're alive and well, control is never an issue. You're able to handle your affairs without any problems. The next stage that people sort of miss and forget about is disability, because we know about 60 to 70% of us will go through a prolonged period of disability prior to us passing away. And so, yes, that's why when I initially said I move away from just talking about it as a will concept as opposed to estate planning, is because if you knew it, I tell my clients this all the time, if you knew the minute, the day, the time that you were going to pass away, then wonderful. Then a will would be just the only document that you ever need, and it would be fine. But because we don't know that, it's only in God's hands. Because we don't know that, then we have to plan for that prolonged period of disability.
Amen.
When we're no longer able to maintain that control, what documentation do we need to have in place to continue to have that control? And I'll talk about that period of disability as well. The third point there is really about subjectivity. What I tell my clients all the time is this is your opportunity to dictate and determine who you want to give to, how you want to give it, and when you want to give it to them. And it's subjective. So whatever criteria you have, it's not the attorney stepping in and saying, you must do this. This is your opportunity at the point to make that determination. And then lastly, it's just all about planning. So the earlier on your plan, the better off you will envision those costs in the long term. And so that's part of why we consider this estate planning rather than just talking about wills. So let's talk about some of those common planning techniques again that we talk, and I'll talk about some of these in more general. The first and the most common of these is, I think about 70 to 80% of us practice this first one. It's called doing nothing and dying intestate.
Wow.
So if you die intestate, that means you die without any sort of plan in place. And I'll talk about what occurs and happens in that situation. The other planning technique is owning property jointly. Joint ownership of property, primarily real property. You'll see that as a technique where people will have a piece of property, primarily married couples, where they'll own a piece of property jointly. And so we'll talk about how that focuses in, or how that brings into the overall estate plan. There is what's called designating a beneficiary. So there are certain policies and assets that you may have, which by contract or by law, you can designate who you want that particular asset or policy to go to. So we'll talk about those in a little bit as well. Then we'll talk about the will. As we mentioned, that's probably what the majority of us know when we talk about estate planning, is to draft a will and to have somebody identified as the executor of that will to handle your estate and your affairs. And we'll talk about that as well. We'll also talk about a living trust. Living trusts are similar to the will. When you pass away, they are the vehicle that allows in this case, we call them a trustee, who allows your trustee to manage your affairs and to distribute your assets as you would want them to be distributed. We'll also talk about a power of attorney. This is the document, when I mentioned earlier disability, this is the main document that handles your affairs during that period of disability. It's a power of attorney. And then lastly, we'll talk about an advance directive for healthcare. So as the name mentions, this document is specifically about healthcare. How do you make the necessary communications with your healthcare professionals if you are not able to communicate? And what you'll figure out as we go along, and I'll let the cat out the bag early, is that all of these can be combined into a comprehensive plan that will be part of everything that you need to do, because they each deal with a different aspect of your estate plan. So let's talk about the first technique a little bit, doing nothing and dying intestate. Again, the most common. There's no plan in place, and it gives all control to the state via what's called intestacy laws. So as we are here in the state of Georgia, within the actual Georgia state code, there is a paragraph listing how property is to be distributed or handled if you were to pass away. So we'll talk about that a little bit. And there really isn't any control, because if you pass away without letting the state or the family, the loved ones know what you want to have done, we have to revert to the code as to how Georgia would prefer to be handled. And in some cases, that may be what you want to have happen, but we find out that in most cases it's not. And so that's something that we don't wish on anybody or recommend to anybody. And it guarantees probate. Probate, and I'll talk about it from this standpoint, probate is not necessarily a bad thing if you've planned for it. Probate is just a process that when you pass away, your estate gets handled or managed. So if you pass away without a will, like in this case, then your loved one, whomever it is, must go to the court. They must petition the court to be appointed what we call the administrator. The only difference between an administrator and an executor is that the executor is there if you have a will, the administrator is there if you do not have a will. And so because there's no document that identifies the person to petition the court, the person typically is a loved one, spouse, surviving spouse, will petition the court to be given the authority to handle the affairs. So as I mentioned, Georgia's code dictates exactly how the distribution is to occur if you were to pass away without a will. So if you die without a will and you leave a spouse but no children, then great, fine. Your entire what we call probate estate goes to your spouse. Now, in most cases, that's ideal. You've been married a long time. You love your spouse, and so if you pass away, you want everything to go to your spouse. So that's a no-brainer. Now, if you pass away and you leave a spouse and children, regardless of age, then half would go to the spouse. And the code has a little a section that says, but not less than 1/3, and that's just a technicality. And then half would go to your children. Again, ideal world, you love your spouse, you love your children equally, you want them all to share. But this part of the code is where reality sort of sets in, and it doesn't really envision, as we go along nowadays, there are blended families where we have children from different marriages. And so what we're dealing here could be a complication, because the children that we're referring to in this situation are all the children of the deceased spouse, and not necessarily the children of the surviving spouse. So again, you can see where there could be some complications and some issues that come about if all of a sudden now a surviving spouse has to share an estate with children of the deceased spouse.
Hey, Tua, that is completely surprising to me. So you're saying that even if the children are grown and have their own families, they are still considered heirs of the estate of their
Absolutely.
deceased.
If there's no plan in place, Georgia law says that children and surviving spouse share alike. Now, there is something that the surviving spouse can do to inherit everything, and it's called file a petition for year support. And that's only really here in Georgia, where you can the surviving spouse can file a petition for what they call year support, which in old common law meant that the surviving spouse is asking the court to set aside a certain amount for their year support. But Georgia law has never really dictated what that means. And so in most cases, the spouse would just ask for the entire estate. But even then, it's a petition for year support, but the children have to agree to that petition. So you can have a situation where they contest it. Now, in most cases, Georgia has sided with the surviving spouse and has granted petition for year support. In fact, one of my early cases when I used to do probate, I really don't focus much on probate anymore. I do more of the planning side of things in the probate. But one of my very first cases was representing the children against the surviving spouse for year support. And the facts of this case were all against the surviving spouse. So I was very confident that the children would prevail. I mean, the surviving spouse had abandoned the deceased spouse, moved out, was in all intents, had not filed for divorce, but in all intents and purposes were separated. Yet the probate court, because again of the strength of this petition for year support, still ended up giving the majority of the estate to the surviving spouse. So again, this is where I tell clients all the time, avoid that lack of control, because you get to make that decision. Do not leave it up to the law and to courts, in essence, to be able to determine how that is to be handled. Amen. So that's just intestacy. So one and probably the most common planning technique. So again, if you don't learn anything from this, make sure you don't pass away intestate and leave the laws to dictate again how the assets are distributed. The next planning technique is owning property jointly. And again, you'll see it very commonly in married couples, but really anybody could be a joint owner. Joint held property has its own rules regarding ownership and transfer of death. So what happens in terms of rule of joint tenancy? It's really a game of survivorship. So if you hold property, and again, it's primarily real property, your primary residence, investment properties, etc. You hold it as joint tenants. Then when one person passes away, their half of the property automatically goes to their surviving spouse, and it doesn't go to their estate. And so it avoids probate in a sense, at least upon the death of the first spouse, everything automatically goes to their surviving spouse. And it has, for probate purposes, again, it's not part of your estate. It may be for tax purposes, but this conversation is really not about taxes. Majority of us won't have an estate tax impact upon death. And so this presentation really doesn't focus on the estate tax. but it's not controlled by wills or trusts. So within your will, if you say you want your share or half of the property to go to Joe, when you pass away, because by law it automatically goes to your spouse or the joint tenant, then it doesn't necessarily, it is not necessarily controlled by wills or trusts. Again, just making sure that you think of estate planning from a holistic standpoint, so that if you do dictate things within your will, make sure that your real property is owned in such a way that would mirror whatever your wishes would be in the will, and it's not subject to probate proceedings. So joint tenancy sounds great, and it's a wonderful thing. In fact, when we do the majority, and as I mentioned, I do real estate transaction closings as well. So the majority of the times when I do a real estate transaction, especially involving couples, I automatically will list them as joint tenants, because Georgia has two designations. So if two people own property together, there are two ways in Georgia primarily that could happen. They can hold it as tenants in common and as joint tenants. Now, the difference between the two is, if two people hold property as tenants in common, when one person passes away, their half of the property doesn't automatically go to the surviving spouse or the surviving tenant. Their half of the property goes into their estate. When two people hold property as joint tenants with right of survivorship, that means when one passes away, their half of the property automatically goes to the surviving spouse. So you would think, hearing those two definitions, what the default rule is in Georgia. And if I had a poll to put up, I would ask, and I bet you the majority of you would think that by default, Georgia would have two people owning property as joint tenants. But it's actually the other way around. So by default, if you do not list in that deed what we call the vesting deed, where you've gained ownership to that property, if you do not put in that deed joint tenants with right of survivorship, then that means you and your spouse or the other joint tenant are automatically as tenants in common. So half of the property, you pass away, it goes to your estate and not to the surviving spouse.
So
again,
the automatic default is tenants in common. Is that right,
correct.
Thua?
That
Okay.
is correct. So look at the deed where you gained ownership, and if it does not have joint tenants with right of survivorship language there, then you are automatically a tenant in common. And again, if you didn't plan properly and have a will listing the spouse as the person to own the property, you could potentially have issues again where now half of your estate is owned by your spouse, or look at the property as a whole. Your half goes into your estate. In the estate now, half is owned by the spouse, half is owned by the children. So you can see how that can cause some additional problems. And so that's why even when we're doing documentation for clients, even if it's a will that doesn't necessarily dictate how property is held, I always have clients go through the exercise of checking their deed to see how title is held, because most clients, when they come and do estate plan, they've owned their property for years. And so their recollection of how they are listed on title is always different than the actual deed itself. And so I have them do that little bit of homework so that when we create this wonderful will that says X should happen, that they don't have a deed out there that is not similar to what X is stating. So the other planning technique is designating a beneficiary. As I mentioned, you'll see it in accounts like your 401k, your life insurance, what we call POD and TOD. That's payable on death, transfer on death accounts. You'll see that primarily as bank accounts, IRAs, where basically you're naming a person to go to be the beneficiary of that particular account. It's commonly known as checking the box, because you're actually checking a box and you're listing who it's to go to. Again, this designation is fine, and it's okay if you're keeping it in the general sense of things, meaning in the general scope of your estate plan as a whole. So within your will, if you say everything is to go to your spouse, and then you have a 401k here that is going to either a prior spouse or to your children before marriage, et cetera, and you forgot to make that change on that policy, it doesn't matter what your will or your trust says. By law, that company has to go by whatever you've listed there. So again, when we're doing, even with wills that don't control this type of an asset, we still have people go through and do a homework and check those so that what they say that they want to have happen mirrors what is happening within the will. And so it's really, again, making sure that they plan while they can to be able to make those distinctions so that your 401k doesn't go to somebody other than who you want it to go to. Because again, most of the time we're doing a lot of these accounts and ownership of properties prior to us really doing our will or doing some estate planning. And so what we think is the case sometimes tends to be different than what we've identified. The other aspect is a will. It does guarantee probate. Again, probate is not a difficult thing, especially here in Georgia. Probate is a fairly simple, I guess you would say, process. It is public record, which is not a difficulty. Now, there is a possibility of multiple probates, and this is where we start getting into more complicated or complex discussions, because one of the things is if you were to pass away owning property in different states, you would have to probate your will in each of those states. So that's where we start looking at, when we're talking with clients, we have a questionnaire that they complete and fill out. And one of those is identifying where your properties are. So if you have properties all in the state of Georgia, wonderful, no real issue. You're a good candidate for a will. If you have properties in different states, you're probably a better candidate for a trust, because with a trust, we can direct all the assets into the trust, as opposed to a will. We can't really direct it. And I'll talk about that distinction shortly. And again, it doesn't control all your property. Remember, there's property that the will can dictate, and then there's other property like joint tenancy properties, designating a beneficiary sort of properties and assets where you listed. So the wills won't control those, because by contract or by law, they go to a particular individual. So the other conversation is a living trust. And the way I always define, or the way I always can explain what the difference between a will and a trust is, I love cars, although I really don't buy fancy cars, but here's before I digress, the way I explain the difference between a will and a trust is I explain it in terms of a car, the same make and model vehicle. So with the trust-based car and the will-based car, when you pass away with the will-based car, that car has to go into the shop to get tires rotated, oil changed before it's ready to go on the journey. That shop in this analogy is the probate court. So it has to go to probate court, petition it, take the will, get an executor appointed, and the executor handles the things that are listed in the will. And then it's ready to sort of go on that journey. With the trust-based car, when you pass away, because you've done tire rotation and oil changes throughout the life of the car, it's automatically ready to go to the journey. So it doesn't have to go into that shop before going on the journey. And so that's really the difference. So you can put the same provisions, you can identify the same individuals to handle it. One, again, in the will car, that's called an executor. In the trust car, that person is called a trustee. But for the most part, it's the same thing. So why is the difference? Why is the trust car ready to go on that journey? It's because during the life of the car, when we create the trust, we do what's called funding the trust, meaning we transfer assets from your individual name to the name of the trust. So you will then own it as trustee of your trust. Again, it sounds fancy, it sounds difficult. The only difference is, and you can manage your affairs as if it were yours directly, no real difference. But the difference is when you pass away, because all your assets are now not in your individual name, they're in the name of your trust, it's automatically ready to be distributed upon your death. So a trust, again, and a will is like that packed suitcase for a trip. It has all the same provisions. It has some provisions in there that you may not ever need or use, but it's in there for your safety. Of course, we as lawyers always look at the worst case scenario. What wrong could happen, and we add provisions in the will or the trust to be able to manage that. Again, it's managed by a trustee. The trustee can be an individual or multiple individuals, or a bank or a corporate trustee, depending on the size of your estate or the complexity of the estate. Again, the trustee and executor are the same individuals. When you pass away, and this is the only thing we'll talk about really about probate, the executor has three main responsibilities when you pass away. They have to gather your assets, pay off your creditors, and distribute your assets. And so it's important to understand that when you identify who you want to serve in that role, think of people that are competent to handle those things, and make sure that you plan appropriately so that you can make sure it makes it easy on them to be able to gather your assets. And what most people don't understand, and that's why step 2 is there, is to pay off creditors. So most people think that, oh, when I pass away, my creditors don't need to be paid off. Well, no, unfortunately, this may be news to you, but the second responsibility of the executor is to pay off creditors. After the creditors get paid off, then the estate, the assets get distributed to your estate or to your beneficiaries.
So is it unusual for the executor to be a beneficiary of the estate?
No, it's not unusual at all, because we typically recommend family members be the executors, primarily because they won't charge the estate. If you go to a lawyer or accountant or somebody else, the law does allow that the executor gets paid, but most family members will do it without any sort of compensation. And so, yes, they can also be a beneficiary because they're still responsible. They have what's called a fiduciary duty. They're still responsible to other beneficiaries to make sure that they manage the estate according to the terms that are listed in the will or the trust.
Wonderful.
The other planning technique is our powers of attorneys and advanced directives. So the powers of attorney, where you give somebody the responsibility, that person is either called your agent or your attorney in fact, and they basically handle all financial matters. So in our case, we make our powers of attorney. So we give every single responsibility, because what you don't want to have happen, and really the powers of attorney is when are only viable when you are still alive, but you cannot handle your affairs. Either you choose not to, or you're just mentally incapable of handling your affairs. So the power of attorney then becomes in force. And we add every single provision in that we can imagine in our powers of attorney, everything from handling taxes, bank accounts, even social media, anything that you can do about, as your individual, we want to incorporate into the powers of attorney, because we don't want a situation where you become disabled. And now if it's not listed in that particular right is not listed in the power of attorney, we now have to do a probate. What most people don't understand, probate isn't just a process for passing away. It's also a process for when you are disabled and can't handle it. One's called a living probate and the other is called a death probate. And most people, when they think of probate, they think of death probate, which is the standard one. But also there is living probate, where you have a loved one that cannot handle their affairs and there's no documentation as to who is supposed to step in and handle their affairs for them. So we add these powers of attorneys in there because, again, we know the majority of us will go through a prolonged period of disability. So we have powers of attorney in place. In general, there are two types of powers of attorney. There's what's called executory and there's what's called springing. So executory, as soon as you sign it, that person, that agent under the power of attorney has the automatic ability to sign on your behalf. Then there's what's called springing. Springing just means an event must occur before that person has the ability to act on your behalf. Typically, the event is either A, I'm still good, I just don't want to handle my affairs, so I sign an affidavit saying, hey, Mr. Agent, Miss Agent, you can sign for me. Or B, I'm no longer able, but a physician signs off, two physicians sign off saying, hey, I'm no longer able to handle my affairs, so Mr. or Mrs. Agent, you can step in and handle it. The reason I mentioned those two types, executory and springing, is because in the estate planning world, we typically do springing. Again, lawyers, we think of worst case scenario. We try and avoid abuse or misuse by somebody because we've now included every single power in this power of attorney. We want to make sure that if the agent acts, it's because somebody else has identified that this person is not able to act on their behalf. And so that's where we do. But again, the powers of attorney are all encompassing. Everything is listed in there so that they have the ability to step in and handle your affairs for you. Again, as soon as you pass away, powers of attorney no longer are in force. Now the will or the trust will take over. The advanced directive is the other form of sort of power of attorney, but it's specifically for healthcare decisions. So there used to be in Georgia, what was called the living will, where you identified how you wanted your medical affairs to be handled. So if you were in a coma or if you had a terminal illness, you would identify in your living will, I want to be kept alive as long as possible, or allow me to pass away, but keep me comfortable, or allow me to pass away, but don't give me this, don't resuscitate me. All these conditions were within it. And I think it's about 4 or 5 years ago, maybe a little bit more, Georgia combined the living will with the healthcare power of attorney into what's called the advance directive. So the advance directive identifies a healthcare agent to make medical decisions on your behalf. And it also directs, what's to happen in terms of everything from organ donation to an autopsy to, do I want to be buried or cremated? What happens if I'm in a coma? What happens if I have a terminal illness? All of those things are incorporated within this advanced directive. So it gives direction to your medical professionals on your level of care.
So Tua, even if I'm listening to this and I don't feel like I have assets or don't need to do anything in terms of disposing of assets, I still need to talk to someone like you for estate planning purposes, if for no other reason to have some clarity about my end of life directives. Is that true?
Absolutely. Absolutely. I mean, and again, it's a holistic approach. So yes, you may not have assets, but I think what I always tell clients, look at it from the standpoint of your loved ones, not necessarily for you. So I always have clients call me up and they always say, oh, my estate is very simple. It's very easy. And then I send them the worksheet and they return it back. And then we start having conversations and you realize it's not as simple as you may think, especially when you have loved ones either depending on you or are interested in understanding how things are to be distributed upon your death. My father passed away 4 years ago, and he passed away without a will. Again, I've been mentioning I'm an estate planning attorney for the last 15 years. So he had a son who was an attorney that did this, and we never could get him to do his plan. And his was fairly simple, but there were little things that we did not know that he wanted to have. It's simple as his burial. We didn't know what type of a burial he wanted. We didn't know where he wanted to be buried because he was originally from Sierra Leone, moved to Liberia, then moved to the United States, I think in probably in the early 2000s. And so we didn't know where he wanted to be buried. Even his wife, my mother of almost 50 years married, didn't know those things. So that's why I always say it's a holistic approach on making those determinations, because what you're trying to do, especially in certain cases, is relieve the pressure of your loved ones when you're not here. From the simple things as how did you want your burial to be conducted? And so we have, and I'll talk about it a little bit briefly, and it actually is a great segue. I'll jump in and I'll come back. But you see the last item on this list is what we call memorial instructions. For my clients, that's homework. So when we meet with you initially, we give you some homework on doing memorial instructions. It's simply, hey, how do you want your funeral to be conducted? Which hymns do you want sung? Who do you want to officiate over your funeral? The little decisions that we don't think are important, again, may be important to your family members, and it provides them direction. So it allows them the ability to grieve for you without having to worry about how things are to be organized. Now I know that mom and dad, they did it. They told us exactly how they wanted to have happen. And so now we can just relax and grieve for them or celebrate them depending on what they wish to have happen.
Wow, that's awesome. Hey,
Yeah,
to a person that's close to me, we were having a discussion, and this person made it clear that they want to be cremated. And of course, me, if I'm left to be responsible for that, that's not something I'm exactly inclined to want to do. And so the place to have those type of things spelled out to get your last wishes would be right here. Is that correct?
And that's absolutely correct. I can't tell you how many times I have conversation with clients about that, and especially spouses, because one spouse wants to be cremated, but the other spouse says, no, if it's up to me, it will be buried. Well, in that case, then you need to make sure that it's written down again. And this memorial instructions aren't mandatory. So that means the family does not have to follow your instructions, but I don't know about you, Kenny, but most of my family members, if I say I want it to be done and I put it in writing, they're going to follow my wishes.
Absolutely.
So it just makes it easier for that person and to avoid any conflict or any issues about what would have happened. Because the worst thing you want to have happen is family members, they're already going to argue about that $25 you left in the will. You don't want them to have that additional sort of argument about, oh no, he wanted to be cremated. No. He told me he wanted to be buried.
Yes.
And I know exactly where he wants to be buried too, in that family plot. Yeah, I know he hasn't talked to the family in years, but he still wants to be buried in that family plot. So I mean, those are some of the conversations that need to happen, and that's why again we have a holistic approach. So this is really what a plan looks like. There are two sets of plans in my firm, and I think that most estate planning attorneys should have. And notice I said estate planning attorneys as opposed to will attorneys, because I'm already trying to get people to understand it's estate plan. It's not wills. It's not just trust. It's estate planning. And so most plans are either a trust-based plan or a will-based plan, where the trust is the central document or the will is the central document. So in a plan, you have a trust or a will. If you have a trust, there's what's called a pour over will. And that's only because, remember, I said everything has to be directed into the trust. Well, we still keep what we call a pour over will. It's just a simple will in there that really tells the executor, hey, I forgot to put something in my trust when I was alive, or I acquired it after the fact. So yeah, take to the court, take that asset I forgot about, put it in, from the will and pour it over into the trust. So that's why it's called a pour over will. So you still have a will, even though you have a trust as well, just to cover all our bases in case we forgot to put something. And then guardianship provisions have to be in the will. So that's where we would put those things there. Now, both of those plans would have the durable power of attorney, as I talked about earlier, for disability, if you were not able to handle your affairs, but you were still alive. Both of those plans would have the advanced directive for medical, for healthcare, or make medical decisions on your behalf. Both of those plans would have a HIPAA authorization form. And most people forget about this, but in order for somebody to make medical decisions on your behalf, they may have to gain access to your medical records. And HIPAA is the federal law that protects the privacy of your medical records. And so there are situations, in fact, even spouses can't access another spouse's medical records unless they've given them the authority to do so.
Wow.
And so within our plan, we have a HIPAA authorization form that says, hey, not only have I identified a healthcare agent to act on my behalf, but I've created a form that says they have the ability to access my medical records to make those decisions for on my behalf. Included there are anatomical gift forms. So if you want to gift your organs to either medical study or in general, then you can do that as well. Again, not mandatory. Memorial instructions, as we talked about, the funeral. And then we have what's called a personal property memorandum, which is just a fancy word for a list, because we know that each of us has so many different items that we can't all place the items in a will or a trust. And so I give just a list that you can list the item and who it's to go to. Because the other thing that typically happens when somebody passes away is that items in the house tend to grow legs and walk out. So we want to avoid that by identifying those items ahead of time and putting it in there. So really this is sort of the list. One of the things I didn't talk about, I mentioned fiduciaries, I mentioned the executor, the trustees, the healthcare agent, the power of attorney agent as well. My firm, what we do is we work in what's called rule of three, meaning for each of those positions, we always identify 3 individuals. So if the first person is not able to or is not alive when you pass away, you have a backup, and then you have a backup to that person. Now, it could be the same 3 individuals to serve as your trustee or your executor or your guardian or healthcare agent. It could be the same 3 individuals, but we always ask that you identify 3 people so that there's no issues upon your death. Because again, worse, we don't want somebody to not be listed. And then now we've got to go to the court and say, hey, identify somebody to be able to handle it.
Because that person that you identify to be primarily to handle everything, on day one may not be the person that's alive when you actually pass. Correct. Right?
Either they're not alive or they frankly don't want to handle, because again, this is not easy. The better you plan, the better you organize, yes, it makes it easier on them, but we know most people, again, myself included, we probably don't plan or organize as best as we can. And so you're making the task very difficult. And so you have to make sure that the person's willing and able to handle those affairs for you. And so that's sort of important. And one of the things we do to try and help is we have a portfolio that we give to our clients. It's really a binder. But in it, we put your estate planning documents, and we also include a section there for other assets. Because again, there are documents, they're the designated beneficiary assets. So your 401k, your life insurance, all those things, even though they're not controlled by the will or the trust, you still want your executor or trustee to be able to know where those items are, so that it makes it easier to handle it. And so we tell clients all the time, anytime you get an asset, a property or anything, hey, make a copy of that documentation, put it in the binder. So when you pass away, one central document that has everything in there, or sorry, one central binder that has all the documents, so that we don't have to make those calls trying to figure out, hey, did Kenny have an asset at John A. Bank, and that we need to figure out how to work that in. So I think that's important.
Wow. Hey, Thua, real quickly. So let's assume you've taken the time to do all of this. You've got a plan in place. Where do you put it?
Well, I tell people you can simply put it in your house. I mean, most people, when a burglar breaks in, they're not going to go to your estate planning binder and pick it up and take it with them. Some people prefer security. So if you do, you can put it in a safe. What I always tell people, if you put it in the safe, make sure that the person you've identified, whether it's your power of attorney agent or your executor, make sure that they have access to that safe. So there's no issue with having to now petition a court to gain access to documents that would have been solved if you had just, so make sure you give them access to that document.
Thua, is there ever any case where you would have those documents recorded in the general court records or anything?
I would not. There are some counties that will allow you to store your asset, your documentation with them, and it's a real minimal cost for about $5 to $10. But most people move and they will forget to call the county. So I say that in the rare case that you are living in your same county and you intend to be there till you pass away, then yes, you can go to your local county clerk of court or probate court, and for like $5, $10, they will store your will there in the court. And it makes it easy in a sense that your executor can then just go to that court. But if you intend to move away or if you do move away, make sure that you understand. And the binder has, in my case, our binder has a place where, because we don't put the original will in the binder, because the original will cannot be redacted, lined out or anything. So we can't even 3-hole punch the original will. So we keep it separate. But within there, we just put, there are some areas there where you can identify where the will is. So if you want to store it with your county court, then you just put in that binder, hey, the original will is stored at Barry County Courthouse, and it makes it easy.
Perfect. Hey, we don't have but a few minutes left, but Thua, let's see if anybody on the line would like to ask a question. This has been tremendous information.
And I'll keep this on because I know sometimes I talk a lot, and so email address or phone number to contact me. Just remind me that we talked on this if you have questions even after this.
Awesome. Does anybody have a question?
I have a silly question. I'm sorry.
No, not at all.
So once you die, like somebody has to contact the lawyer, or how does it, start?
So it depends. Our documents are pretty straightforward in terms of, if you read them, they're just simple, and there's not a lot of legalese or legal technical jargon in there. So some people, you can just get the will, read through it, and take it to the court and file the petition. Even the forms that you have to file a petition with the court has them, and you can fill it out. You can call us if you need to, and I tell some clients, because on every document that we create, we have our phone number in there, the cards in there and everything. So call us if you need us. You don't necessarily need a lawyer to file it, but we can assist if you need us to, because again, it may seem simple for me about the probate process, but for most people, if you haven't had a loved one pass away, you have no idea what that process entails.
Good question.
I
Jen.
guess, well, let me explain. So, like, I'm a single mom, and so I don't really have a lot of family around here.
Mhm.
So, like, if I went to a lawyer's office and had a will created,
Mhm.
somebody still has to come to tell you when I deceased, right?
Well, they don't have to come and tell me. So what'll happen is if you came to me, went to a lawyer's office, created the will,
Mhm.
remember we'd have the same conversation. I know you said you didn't have many family members, but you still need to identify 3 people. And then what I would say is make sure those 3 people either have a copy of your documents, or you know where, especially number 1, where the documents are. So if you were to pass away, that person knows, because hopefully that's a close person to you. They know you passed away. They know where your documents are. They're able to come take the documents, take them to the court, and get it petitioned so that your estate gets distributed and handled based on how you want it to be. Again, if they need to call the attorney, that's fine. Within those documentation, my number is there. They'll call and say, hey, she's passed away. I'll say, okay, everything's in the binder there. If you need our assistance, let us know. We can assist you in filing the petition. If not, this is what you need to do in terms of sending those documentation to. And I always tell my clients that the very first meeting after we pass away is absolutely free, because I want to direct the family members in sort of the right direction as to what they need to do. But if you need my assistance, yes, there's a cost and charge, and we can help in the process.
Wow. Good question, Jen.
Mhm.
Wasn't a crazy question at all. Anybody else got a question for Mr. Thua before we end tonight?
And I know it's a lot of information. So again, I'll forward Kenny the presentation. If you have any questions at all, feel free to either call or email, and we'll try and respond.
Going once.
I know it's a lot of material, so I don't really.
Thua, this has been great. I can't tell you how valuable this information is. I think it's going to be to a lot of people. And I would encourage everybody, particularly those of us that are really faith oriented, that like to get things done decent and in order, as the good book says, is to really take to heart the information you've received here tonight, and to make a phone call. Thua, is it ever too early to start estate planning?
No, it's not. Not at all. If you have any sort of family members, loved ones, assets, you always plan. What I always tell people is estate planning is like taking a picture in time. So we take a picture as of now, because we know that things may change. You know, there's family, there's the 3, there's death, divorce, marriage, birth, etc. Changes that could affect the plan. You would always amend and change the trust based on that. So don't wait till it's too late. But it's always important to plan.
Awesome. With Thua Barlay, the attorney for Luter, Larkin, and Hunter, good friend of mine, as well as Ms. Carol Lumpkin. It's so good to have you with us tonight to distinguish between what I have so incorrectly called wills and estate to a more appropriate title, which is estate planning.
Absolutely.
And so thank you for sharing with the group tonight. I will get this PowerPoint from Thua and share it with those that would like to have a copy. Thua, any closing thoughts tonight?
No, not at all. Again, I know it's a lot of information. Again, the most important thing is just understanding planning, understanding the holistic approach of things to make sure that everything is sort of identified. But I would leave you with just making sure that you do the appropriate plan in place. Again, not necessarily calling me, but making sure that you call somebody, and at least you have sort of an understanding of what needs to be provided to you in terms of documentation.
Amen.
So, that's a good.
Thua, thanks again. Thanks to everybody for joining us tonight. Don't forget, next week we're going to have Tracy Tomas with us as we continue with Mental Health Awareness Month. Thua, give all our best to Andrea and the kids, and
thank you.
Thank everybody. Have a good night.
All right.
All right.
Hey, Kenny.
Hey.
How you doing? Thua is on this. Tua's from Indiana, correct?
I went to, yes, I went to school there. Yes. I keep saying I'm a Hoosier, but I was only there 10 years, and I've been in Georgia now for over 10 years. But yes, I consider myself from that area. Yes.
Oh, okay, because I was just wondering if you knew a lawyer by the name of Lee Berry. That's all.
Lee Berry doesn't sound familiar. Is he in in Indiana or here?
Yes, he's in Indiana. I mean, but you know, Indiana is a big state, so
It is.
I understand that. But
If he
he
was,
is a
yeah, if he was
Goshen.
in Indianapolis, I probably would have run into him, but the name doesn't ring a bell right now.
Okay, thank you. That's all. I was just wondering.
All right.
That's your brother?
Yes, he's a
right?
lawyer. Yes.
And what kind?
I'm sorry.
Uh-oh.
I'm sorry, Kenny.
I think Kenny may have.
I'm sorry, I think my line went out. Mercy, what kind of lawyer is your brother?
Now he is more of a what?
Family law.
Family law. Yeah,
And is
thank
he
you.
in Indianapolis?
No. He is in Goshen, Indiana.
Okay, so that's probably where I wouldn't know him because I spent all the 10 years were in Indianapolis, so I would only know the lawyers in that city. And again, 4 days after my last law school exam, I moved. So.
Oh, okay. Okay. All right.
All right, good question. Thanks so much,
Okay.
everybody. Tua, thanks again, and have a great
All right.
rest of the week, okay?
Thank you too, Kenny. Take
Okay.
care.
Bye-bye.
All right, bye-bye.
Bye.